My Lords, we were looking at the Kent LFA. Just to finish on that, we were in the supplementary documents bundle at page 475.
Yeah.
And I'd made the point about stakeholder proceeds being different to proceeds. And then just to finish off the presentation of this LFA, you have noted that the funder's fee in this LFA is set out at 9.2. The funder's fee shall be payable as set out in the priority deed and calculated as follows. And no trace in that mechanism at all of any reference to proceeds or stakeholder proceeds. So again, not a case at all where it's determined by reference to damages, nor indeed determined by reference to stakeholder proceeds. It's not an express cap case. At best, it's implicit because it's the source as set out in 9.1.6, but not at all the sort of arrangement which you might.
So is this one doesn't have an express cap?
Correct. That's right. So what you'll see in 9.1.1 and 9.1.6 reflected in also the clause that Mr. Bacon showed you, 3.2.12.5.
Sorry, where are you reading from?
I'm in the Kent LFA. I was showing you clause 9.1.6, which is on this page.
Yeah.
There is a prior clause 9.1.1.
Yeah.
And then there was the clause that Mr. Bacon showed you earlier, which is 3.2.
Oh, so there is a cap in 9.1.6.
Well, it's directing from which source, from which pot, the obligation to pay arises. But the mechanism for determining the funder's fee is 9.2.
So, is there anything in the contract which precludes the funder from pursuing a class representative for the balance of the funder's fee if it's not paid out of the proceeds?
It's understood. That's certainly the intention of the parties.
It's a sort of implicit understanding.
Exactly.
Okay.
And you can find that in as I say, 9.1.1, 9.1.6, and 3.2.12.5.
Yeah.
But so far as determining the funder's fee, within the true meaning of those words, it's 9.2.
Okay.
Now,
just looking at 9.2, isn't the answer to the question you were giving dependent on what it says in the priorities deed?
What does it say in the priorities?
Well, only because I'm reading 9.2 and it says the funder's fee shall be payable as set out in the priorities deed. So that felt like you need to read the priorities deed to know.
I think that identifies the sequence of events, but it doesn't identify the amount
I see. Okay.
that is the funder's fee.
Is the priorities deed is just a waterfall, is it?
It is. Now, I'm about to show you that in the CICC case, the waterfall is determinative in the opt-out proceedings, but it's different in Kent, where the funder's fee, the funder's entitlement, is found in 9.2.
Okay.
Now, I wanted to go back to CICC, opt-out, to make a different point now. So here we are in the supplemental bundle at tab A4, and I'll take you back, if I may, towards to the annex, which is at page 59. And here I will pick up on my Lord Justice Percy's comment about reading the priorities agreement, because in the CICC opt-out and opt-in arrangements, you do have to look at that as well. Now, the point I start with here is that it's right, it is true that the sum total of all of the things listed on page 59, sub A to sub D, shall not exceed the proceeds that have not been distributed. So undistributed damages plus recovered costs. But it is all of those things. There is no other relationship between what the funder is going to receive whether by way of capital outlay being paid back or by way of return, and the level of undistributed damages and costs on the other hand. The limit or cap applies to all of these four things together.
Yeah.
And when you recognise that, I submit that it's very difficult to see how it can be suggested that the amount payable to the funder is determined by reference to the amount of the financial benefit in any meaningful sense. And that point, my lords, is reinforced by the fact that the payment of the funder is the subject of the waterfall. We've looked at clause 9.1, which says it's payable in accordance with the waterfall. You were shown yesterday that definition. It's in the key terms. I won't take you back there, and they refer to the priorities agreement. So to find out what the funder is actually entitled to out of the total fee, you have to look at the priorities agreement. Now, let me just show you that. It's at A3. And we can pick this up at page 25. So opt-out priorities agreement. Hit tab A3, page 25. So,
Sorry.
I'm in clause 2, headed repayment.
Page 25.
Page 25 of the supplementary bundle of documents. Now, under the clause headed repayment, you will see the waterfall is set out and triggered by the receipt of proceeds, which was the point I was making earlier. And the waterfall describes how the total fee gets paid out. First, we have at 2.1.1, pro rata and pari passu to the funder an amount equal to its capital outlay plus interest. And pari passu an amount to the insurer reflecting its outlay and any insured losses actually paid out. Secondly, 2.1.2, solicitor and counsel fees outstanding, including any uplifts. And then thirdly, at 2.1.3, the balance of the total fee, made up of those four things you saw in Annex 6, is apportioned 16% to the insurer and 84% to the funder. So I'm just showing you this so that you can understand in the opt-out arrangements in CICC how it actually works, which is that the amount payable to the funder is a portion of the total fee paid in accordance with clause 2 of the priorities agreement. First, an amount equal to capital outlay plus interest under 2.1.1. And then later, after solicitors and counsel get paid, 84% of the balance of the total fee, which is in itself made up of four different things set out in Annex 6. Again, the notion that because the total fee cannot be more than undistributed damages plus recovered costs, that somehow determines what the funder is to receive, is in my submission, when you actually look at these agreements, completely unsustainable. What you have is a highly indirect and fluid relationship between what the funder ends up with, and the total amount of undistributed damages and costs. There is no realistic world in which you can say that the latter determines the former.
And Mr. Saul, would you accept that Mr. Pitchin is right, that if the case goes on a long time and so the multiplier goes up and the total return in damages is low, or the total undistributed amount of money is low, there comes a point at which what the funder received will be, in part, caused by the value of the amount of damages.
I'm not saying, my lord, that there is no relationship whatsoever at all. But it is...
Because the source of the money is the damages anyway, so
I'm not suggesting that's not
the source of the total fee will always be the damages.
But when you are looking We've been dealing with it yesterday and this morning on the basis of broad propositions, and we say we're right on those. But when you actually look at these contracts that this court is deciding the case on the basis of, as well as looking at big principles, the notion that this funder's fee in this case is determined by reference to undistributed damages and costs is unrealistic in the extreme. There are so many steps you've got to go through before you work out what the fund is entitled to. And there does need to be an exercise of standing back here and looking at contractual reality, which is what the tribunal said at first instance, paragraphs 57 to 59 and 62 and 63. It's squarely consistent with what the Supreme Court said in Packard, where it said focus on the primary contractual entitlement. It is squarely consistent with the architecture of the CAT at Rule 93(4) and Section 47C. It is squarely consistent with access to justice. It's exactly what you would expect to be contracted for here.
You would say that for the appellants to be right, they would have to be written into the statutory provisions, whether directly or indirectly, wholly or partially.
It would have to be clear that what was intended to be captured was any possible relationship of any kind between funder's return and...
So you might add in howsoever remote.
It's remote in the extreme here. Now, if I'm just going to turn next to the opt-in LFA. I'm moving on from the CICC opt-out arrangements. Before I do, one clarification. I'd mentioned I was dealing with the big picture point about many multiples and these funders could end up with a lot of money. And I'd explained that we weren't in the foothills of the CICC proceedings at all. I referred to CICC leading the third trial or trial 3. My understanding is it's correctly described as trial 2B, whereas there's been trials 1A and 1 and 2A. We weren't expressly parties to those, but there's an expectation that their outcome will have an effect on the CICC proceedings. But on any view, not in the foothills of this interchange litigation of which these proceedings form part. CICC opt-in next, please. Now here, for my Lord's note, only one LFA exists that covers both the claim against Visa and the claim against Mastercard. The LFA in the opt-in proceedings, as my learned friend Mr. Bacon mentioned earlier, is an agreement between the funder and the solicitors, Harkus Parker. It is not an agreement between the funder and the class representative. What is happening here is that Harkus Parker have themselves entered into a DBA with the class representative, permitted, of course, in opt-in collective proceedings, which entitles them to approximately 32% of the damages recovered with certain adjustments applicable in respect of recovered costs. The original opt-in LFA was dated 7th of April 2022, but shortly before the hearing in front of the CAT, which was on the 10th of November, an amended and restated version of the opt-in LFA was produced. It was that version which was the subject of the decision at first instance. It was at that stage in draft and unexecuted. So this touches on my Lord the Chancellor's question about what was executed and what was not. The opt-in, the revised opt-in LFA was not executed at the time it was considered by the CAT on the 10th of November. But it was that document that it based its decision on, and it's that document which is the subject of debate before this court, and you will find it in your supplementary bundle of documents at tab A5. Although not executed in the form in the bundles, because that's the document that the CAT had and therefore what was considered appropriate for it to be the one you have, it has since been executed. There is also a priorities agreement in place in relation to the opt-in claims. Again, this is one priorities agreement for both opt-in claims, and it is the amended and restated priorities agreement is the relevant one, which you will find at tab A6 and also the same document at tab B5. And then for completeness, so you're aware, both the LFA and the priorities agreement were the subject of further amendment in December last year, copies provided to the other side in January, no points are taken. Now, particular points in relation to the opt-in LFAs, above and beyond the point made by my learned friend Mr. Bacon that we don't accept that a an arrangement of this nature where the litigation funder is sharing in the solicitor's receipts as a DBA, that's not an issue that is before this court. I will focus on the point that is. Now, if we turn up this LFA at tab A5, page 63, it is clause 3.1 that sets out the funder's contractual entitlement. Page 64 of the agreement. The funder is entitled to receive a payment out of the proceeds in accordance with the waterfall. And at clause 3.2, you see a similar clause to the one found in the other LFA about subject to the terms of an order and so on. Now, the counterparty here to the agreement is Harkus Parker. You can see that at the top of page 64. It's defined as the counterparty. Now, to understand the payment obligation at 3.1, one has to look at the definitions because there are references to proceeds and waterfall. You find those, my lords, in Annex 1, which starts at page 72. Proceeds is different here. It's at page 75, the definition of proceeds. Any and all value due to and or received by or in lieu of payment to the counterparty, i.e. the solicitors. The reference to DBA, that's defined on the previous page, which is the damages-based agreement entered into by the counterparty in respect of the claims, and claims means the opt-in claims. That's defined on the previous page. Now, so proceeds is such amount as Harkus Parker is entitled to under its DBA. Now, the next definition we need to look at was waterfall. That's on page 76. That's got the meaning given in the key terms. The key terms are found at page 79. And it's similar to what was found in the opt-out LFA, which is it refers you back to the priorities agreement. So to understand here what the funder is entitled to, we have to look at the priorities agreement.
Yeah.
Which we find at A6 of this funder, page 82. And it's again clause 2, repayment. You will see again it's triggered on receipt of any proceeds, which is, as I said, the receipts by the solicitors under their DBA. And then we have the clauses that set out the waterfall. First of all, to the funder, an amount equal to capital outlay plus interest, and to the insurers, effectively insurer outlay and amounts paid out with some provisos that we don't need to trouble ourselves with here. The second limb of the waterfall is 2.1.2, payments to council. Thirdly, and here we see the conditional wording, which I'll come to on issue 2. Subject to this clause 2.1.3 being enforceable and or permitted by applicable law, failing which clause 2.1.5 shall apply. The residual amount applied in the percentages set out there, with a proviso. Fourth, another level of the waterfall on a percentage basis, but with the conditional language. And then 5 is if clause 2.1.3 is unenforceable, then you go to this and you pay the funder an amount of its capital outlay again. You pay the insurer the amounts set out in the endorsements to its policy, which I'll come to. And then finally, the balance is 2.1.6, which is an amount to the funder, which is a multiplier of its capital outlay. And then the solicitors at little b take the balance. And then finally here you have the clause that the appellants rely upon at 2.1.7, notwithstanding any other provision, the fees paid pursuant to the above waterfall shall not exceed the total amount of the proceeds. Once again, and it's a similar point having looked at the language as I made as my second point on the opt-out agreements, which is that the relationship between proceeds and the amount that the funder receives is remote in the extreme. This is not even a situation where it's the higher of or the lower of. It is a series of steps with payments to funders, insurers and council, all of which together are not to exceed, not even proceeds in the conventional sense, but proceeds as defined, which is the amount that the solicitors recover under their DBA. So the notion again that recoveries, damages plus
The
costs.
proceeds in this waterfall, this priorities agreement, on what the solicitors recover
It
under
is.
the DBA.
It is. That's right. And even then, if you were to treat
That's
that...
not the damages at all.
No. No, my learned friend will say for the appellants, well, it's a subset, because the DBA can only capture 32% of what's recovered because of the terms of the DBA. So he will say it's a subset, but still, it's different. And you still have the further point that it is not the simple question of the funder's fee being capped in some clear and direct way by those 32% of recoveries. It's much more complex than that. All of these payments out, including council under CFAs, insurer outlay, and so on and so forth, are limited in this way. That is not, in my submission, at all what 58AA3A2 is contemplating when it talks about determined by reference to, no matter how broadly you interpret that language. Turning next, my lords, to the ATE policy.
You could, by adopting, if you start from the proposition that one way or another everything comes in an opt-out case from the return, and you said determined by necessarily had to be construed by reference to that fact, i.e. caught everything, then you are caught. But I mean, it has to be that broad.
It would have to be...
These sorts of arrangements are captured.
I mean, these are opt-in arrangements.
These are opt-in, yes.
But it would have to be an incredibly broad, I mean, the absolutely maximalist interpretation of 58AA3A2. I'm going to say that incorrectly.
Yeah.
It would have to be the maximalist definition or interpretation in order for this sort of agreement to be captured.
Yeah.
ATE policies, if I may. Now, just again, so the court has the structure of this, there are 2 ATE policies in total. One for the Visa opt-in and opt-out claims, that's at Supplemental Bundle A1, and one for the Mastercard opt-in and opt-out claims, that's at Supplemental Bundle B1. The terms of the policies are materially the same. Now, what they provide for are 3 payments to the insurer. First of all, an initial upfront premium. Secondly, a further upfront premium payable within 30 days of certification. And thirdly, a deferred premium payable on success. Now, the policies were amended prior to the hearing below by way of a draft endorsement, which is endorsement number 2. It has since been executed in a materially similar form, and it provides that deferred element of the premium is a staged premium by reference to a fixed sum, which varies depending on how far the proceedings get, which is typical for ATE policies. Now, at all times, and I won't trace back through the agreements at this stage, but at all times, the deferred premium failed to be paid in accordance with the priorities agreement. And you don't have to take that from me, but you can see it when you come to look at these policies in more detail in your own time, my lords, that if you look at the definition of deferred premium in the policy, it says that in terms, payable in accordance with the priorities agreement. Which means in practice, because of what we've seen before in the priorities agreement, it's payable out of undistributed damages and recovered costs. And it is subject to that waterfall that we've just looked at, on the one hand in the opt-out and on the other hand in the opt-in. Now, all of the points made by my learned friend Mr. Bacon apply here, but we also have separate points. First of all, the initial upfront premium and the further upfront premium are payable whether or not recoveries are made, not in any way determined by reference to proceeds or recoveries. You'll see this in Supplemental Bundle A1, page 7. We're looking here at the visa policy. Supplemental Bundle A1, page 7, visa and AT policy, clause 4.1.
Hang on, supplementary bundle.
So same bundle, it should be the same, the one
Yeah.
you've got on the list.
Tab.
Tab A1, the first tab,
Yeah.
page 7. So here you have it's clause 4 that sets out the payment obligations. You can see 4.1 refers to initial upfront premium within 30 days of inception date, and then further upfront premium as specified in paragraph.
Not non-refundable irrespective of
Exactly.
outcome. Yeah.
So that's not a DBA. This agreement is not a DBA, not at all what's being contemplated in 58AA3A. You
Yeah.
can then turn up the endorsement I mentioned at tab A10, which identifies the deferred premium payable.
Page
Page 157.
157.
And as I say, for Visa and Mastercard, these documents are materially the same. So I'm just showing you the Visa ones for convenience, but you can see it's a 3-stage arrangement now. Stage 1, 4 million in the event that, of a successful outcome during stage 1, and that's until the 135th day after the CPO is granted. Stage 2 is 5 million, and that is engaged until the day before the trial on liability and quantum. And stage 3 steps up again if it settles during the last phase, settles or is resolved by other successful outcome.
Yeah.
So not in any way determined by reference to damages. Now, what you are left with, of course, is that this is payable in accordance, as I mentioned, the deferred premium, but the deferred premium only is payable in accordance with the priorities agreements which we've looked at. Opt-in and opt-out are different regimes in the priorities agreements, and they form part of the waterfall. So when you're looking at the deferred premium, the same arguments I've made in relation to opt-in and opt-out apply here, namely, you're looking at a collection of things, of which these payments, these amounts are one, all of which together must not exceed the total fee in the case of opt-out or the proceeds in the case of opt-in. Hardly the sort of relationship that one might imagine the statute had in mind when it was talking about determined by reference to. Here we have an upfront premium, it's a fixed sum, and another upfront premium, which is a fixed sum payable in any event. Thirdly, a deferred premium, which is a fixed sum and which falls to be paid in pursuant to a waterfall, where the total aggregate of all of those payments in the waterfall can't exceed the obvious and inevitable limit. That's not determined by reference to the specified financial benefit. My Lords, those were my submissions on the agreements. I will be looking at Neill, but I'm going to be looking at that in more detail in the context of issues 2 and 3, to which I now propose to turn. Oh yes, I'm sorry, I skipped some points in my notes which I meant to come back to, and Mr. Bacon's helpfully reminded me. There is a reservation to make generally, is that we do not accept, for the avoidance of any doubt, and it was not accepted below, that AT policies qualify as DBAs in any event.
I know, I'm slightly puzzled by why we're dealing with them, really.
Well, it's a slightly surprising submission. Below, it was said in terms that there are other reasons, wider reasons, why AT policies are not DBAs, the tribunal decided expressly, I can give you the reference when I find the passage in my notes, said it would not deal with the point. It's paragraph 34 of their judgment. They said they wouldn't deal with the point because it was effectively moot, because if the appellants were right on the determined by reference to point generally, then the funding agreements had severe problems, possibly fatal problems, and so the questions around ATE and whether they are DBAs for other reasons were effectively not by the by, because all of the funding arrangements would have to be revisited in some way. That's the way the tribunal dealt with it. It's as a result of that path that this broader question is not part of the list of issues before you, and that was an observation my Lord the Chancellor made yesterday in exchanges with my learned friend Mr. Pichinen. And so you are not being asked, certainly doesn't form part of the list of issues, not addressed by my learned friends in writing or orally, this question about whether ATE policies, or indeed opt-in LFAs of the nature, the kind found here, are DBAs. But I just make it clear, as it was made clear below, we have additional points to make. And you won't be surprised to know what they are, but insurers are subject to a completely different regulatory regime.
I was going to say, these insurance policies don't fall within this particular series of
it's
regimes,
not
full stop.
It's not claims management services.
Regulated by
I'm not
any of these.
I don't propose to develop the points at length because I'm conscious of what my learned friend said yesterday, and it's right. He's right. It's not in the list of issues before this court, and he's not come prepared to argue the point. But
Why are we arguing? Why are we dealing with it at all?
Well, because there is the debate before you is taking place on this set. It would appear on the set of a series of hypothetical assumptions, and as I understand it, because you're dealing with determined by reference to in other contexts, it's being suggested it applies also to ATE. But we say, as I say, that even if we were wrong on the points I've just made and the points my learned friend Mr. Bacon made this morning and yesterday afternoon, there are other points. Insurers are subject to a complete different regulatory regime.
I suppose what may be said against, well, not against you, what may be said, just looking at the grounds of appeal, at tab 5 of the core bundle, the grounds of appeal of the CICC appeal include the tribunal erred in finding the ATE policies were not DBAs.
No, I appreciate, my Lord. I've come in at a somewhat late stage in the procedural history here, and I'm trying to do my best in the circumstances. Recognise that point. Now,
I don't think Mr. Pichinen really directed any submissions to ATE policies at all.
No, he didn't. He had an exchange with my Lord. My Lord said, well, it's not before us. He said he agreed, and he said he'd deal with it by way of reply if necessary.
Well, we've got enough points to deal with without dealing with points that we don't need.
Well, I respectfully agree with that, my Lord, but I just flag the point.
Okay. All right.
And just by way of example, the DBA regulations were made by the Lord Chancellor, but regulations governing insurers have to be made by the Treasury. They just don't apply at all.
Yeah.
But I'll move on,
Yeah.
having put the marker down to issue 2.
Okay, issue 2.
My Lords, this relates to what we call in the skeletons the conditional enforceability clauses, or what the appellants describe as the wording, which struck me as a race to the bottom for the worst shorthand available for this language. The issue only arises in relation to the CICC opt-in arrangements and the Neill LFA. It's really quite a straightforward point. First of all, let's orientate ourselves. The world we are in here is that we on this side of the court are right on issue 1. If we're wrong on issue 1, we have to tear everything up, the appellants say. If we're right on issue 1, they say that in CICC opt-in and Neill, there is a further point they take. Look, because there is language around percentage payments, albeit subject to express conditionality, they say they're still DBAs, even if they've lost on their prior wider point. So the starting point for this debate is that, and it's also the starting point for the debate on issue 3, and that's important for reasons I'll come on to.
Yeah.
The starting point is that nothing else in these contracts is unlawful, unenforceable, or impermissible. The starting point on the basis of issue 1 is that nothing else is a DBA. And it's only this particular language, providing for a percentage payment to the extent enforceable by law, which is the subject of criticism. Now, my simple submission on this is that the language, to the extent enforceable or permissible by law, does what it says on the tin. It is the sort of language in use up and down the country in all sorts of contracts. You ask yourself, first of all, is the provision in question enforceable or permissible in law? If the answer is no, the language is of no contractual effect. It really is as simple as that. And we've said in the skeleton that we've produced that you cannot escape the straightforward logic of that argument, and that's correct. And against that background, you can't realistically suggest, you can't suggest at all, that where the clause is not operative, not engaged, nevertheless, the contract provides for the amount payable to be determined by reference to that language, the percentage. That language is just not operative. So 58.3a2 is just not engaged. Of course, the opposite position is that language is enforceable, and then there's no problem. You don't run into difficulties with the regs or with Section 47C because it's enforceable. And that's the clear intention of the parties here, and the objectively construed in accordance with all the authorities on contractual interpretation. It's clearly what the right
It's simply done to
interpretation is.
avoid the necessity of entering into yet another amended agreement in due course and getting that agreed by everybody.
Quite so, my lord. That's exactly what the draftsman clearly had in mind. I say that on an objective basis. Now, we just looked at the CICC opt-in priorities agreement. We can, if useful, just turn it up again to look at how the language works.
In one sense, adopting an extraordinarily broad meaning of the word determined, you can see that jumping through a number of hoops, you might get into it, as Mr. Pitchinen said yesterday. But your argument and the argument you've been taking us through in relation by reference to the contracts we've seen this morning and this afternoon, you would say it's almost one step beyond those sorts of contracts. It's even more remote because at the moment the premise of the contract is you can't do it.
Exactly.
And therefore you've got to do what is in the contract but for that clause.
Of course I understand his submission. His submission is the mere fact that those words appear mean that there are hypothetical worlds in which it might be determined by reference to that percentage.
Is it not really a variant of the argument which falls under issue 1?
I'm sorry, I didn't hear that.
Is it a variant really of the argument under issue 1 about the meaning of directness?
Maybe,
Mr. Pitchin is, I
maybe
think, right
ta-
as a matter of linguistics.
maybe taken to its absolute extreme. If any reference, howsoever contingent or hypothetical, then again, if you might characterise it as a sort of issue 1 on steroids, if you like.
Because of the word provided for.
And yes,
It is
maybe.
provided, but whether it's provision or determination is another matter. Anyway,
the word what provides in 3A before you end up with the 2 sublinks.
yeah, whatever you write down.
Does it depend?
That
on
would have to be the argument.
Does it depend on what objectively one would interpret the reason why it's in the contract now? Does that matter? I think it does, doesn't it? I mean, why is it there?
Well,
It's there for a reason, and the reason Mr. Pitchin says it's there is it creates an incentive.
the reason is
That's an unlawful incentive.
that there's a I'll come on to the incentive point in a moment, but the reason it's there is because there is a possibility that such a provision might be enforceable, whether as a result of reversal of PACR by way of case law or legislation or something else. And in that eventuality, the parties want to be able to contract on those terms without having to draft a new contract. I don't think it's any more, this is a pretty straightforward passage of the contract, I would suggest. But the fact that how the parties intended this to work is apparent from the clauses. If we turn back to the opt-in LFA, opt-in priorities agreement, which we were looking at a moment ago, page 84 of the supplementary bundle. So this is the start of the repayment clause. You find the clauses in question at the bottom of 85 and on to 86. And these clauses are not operative, and the parties have contracted. If Mr. Pitchin is right, I should correct myself, that the percentage payments here are not permissible, and we've reserved our position on LFAs of this nature. But if he's right, then 2.1.3 is not engaged, and the parties have expressly identified in the language of the contract how the contract is to work, failing which, so I'm in 2.1.3, failing which, clause 2.1.5 shall apply. And the same, you will find the same in 2.1.4. You'll see the language of failing which, clause 2.1.6 shall apply. So again, and with apologies if I'm making the same point using different words, but if, as the appellants say, the percentage provisions here are unenforceable, they do not apply. And the clauses which ex hypothesi are not DBAs, because we've won on issue 1, apply. And the same is true for Neill, which is the other case where this issue arises. And we can turn up, please, tab C3. We looked at this agreement a little bit earlier. And it's page 375, please. And it's at the bottom of 375, paragraph 11.1 identifies the funder's fee shall be the greater of a multiple of the cost limit, or only to the extent enforceable and permitted a percentage. And then that language, only to the extent enforceable and permitted by law, is repeated.
Sorry, which paragraph?
I'm sorry, I'm in, so page 375, I'm in the Neill LFA
375.
of the supplementary bundle.
Yes.
I'm at clause 11.1 at the bottom of the page.
It's top of 376.
Yeah, it's in 376.
Yes.
Oh yeah, got it. Okay.
And you'll see the only to the extent enforceable and permitted is repeated multiple times within the box, as well as in the overall language.
Yeah.
So what the parties are intending to achieve here is absolutely clear. And what they're trying to achieve is a lawful, enforceable, permissible contract. And they've used standard language to achieve that. And the CAT was right in my submission to consider that the parties were entitled to proceed in that way and that there's no basis for interfering with their freedom of contract. The obligation to pay the funder this amount simply does not come into existence unless and until that specified condition, enforceability and permitted by law, is fulfilled. And I would just...
Mr. Pitchin disagrees with that. He says it's provided in the contract, because there it is in black and white, and it is by reference to something which is a DBA.
Well, I just say those clauses aren't effective.
Yeah.
I mean, that's effectively the choice. I've got some points on interpretation and policy to come quickly.
Well, the policy is, I think, pretty transparent. It is that if it's allowed, we want to go back to it, please.
Yeah.
Now, there is the
Without
subsidiary
making a new
point.
contract.
Yeah, without making a new contract and having to renegotiate everything.
That's right.
Then it's said that there's a broader policy, which is by having that in, you incentivise the taking of a greater degree of risk than is warranted by way of public policy.
I'll come back to that, if I
Can
may.
I just ask, what would happen if the law was changed by statute but it wasn't backdated? What happens then?
Well, if the law was changed by statute and wasn't backdated, depends what wasn't backdated means
Well, I
in
mean,
this
the, effect,
context.
the
But if it's effective going forward, then the contract will be permissible going forward. These clauses would be lawful going forward.
Well, if it were the case, for example, that the payment of the proceeds occurs after the law is changed, even if the law is only prospective, then these clauses would bite, wouldn't they?
Either because the CAT makes an order or it approves the settlement under Rule 93 or 94, whatever it is.
When the CAT looks at the agreement for the purposes of assessing
That's the question.
how the priorities agreement works, the clauses will take
Exactly.
effect.
It's a form of words that is designed to be able to alter the parties' contractual rights and obligations as and when there might be a change in the position. So it lives effectively. There's a slight risk of overcomplicating the discussion, I suspect, but because the words are pretty clear. Can I just close on this point?
We're not expressing a definitive view on that. That might be litigation for the future.
I'm sorry?
We're not expressing a definitive view on that. That's as to whether it's prospective or, that may be something for the future.
Yes, indeed. Now, can I just make some policy points in response, including at the contractual interpretation level? The first is that the appellant's argument has the effect not only that this language does not do what it says, but worse, we achieve the exact opposite outcome. So not only would the provisions be operative or in some way effective such that they still bite for the purposes of section 58AA3A2, but then the consequence that follows, the result for which the appellants contend, is that the entire agreements of which these clauses form part are unenforceable. Because of course they say that severance isn't available either, and that we're wrong on Zuberi and how that works. So the effect of their interpretation is that the clear intention of the parties is not only frustrated, but the exact opposite outcome is achieved. And that, in my submission, is an absurd interpretation of the contract. And here, we rely on some of the observations made by the Supreme Court in Egon Zehnder and Tillman, a case primarily about severance, as you know, but that contains some broader observations on what was described as the validity principle. And if we could please turn up authorities file 2, I have them in 2 files. It's tab B16. I'll just point my lords to the passages. So authorities B16, page 721, is the start of the case. Restraint of trade post-termination covenant case, as you know. And you can pick up the relevant passage 735, please. And it's paragraph 38 to paragraph 42. And there's a reference to the original formulation in Latin, which nowadays few people understand. The validity principle proceeds on the premise that the parties to a contract or other instrument will have intended it to be valid. It therefore provides that in circumstances in which a clause is their contract is capable of having 2 meanings, one which would result in its being void and the other which would result in its being valid. The latter should be referred.
Wait, which paragraph are you reading
I'm
from?
sorry, I'm page 735, paragraph 38. And it's the reference to the validity principle in the second line that's then explained in the sentence that starts, it therefore provides that. Now, in my submission, we don't even need to get into this because this isn't a case of such ambiguity that one has to enter into this sort of territory. But if there was any doubt at all in my lord's minds, then the answer is found in the validity principle. The Supreme Court goes on to consider it until the end of paragraph 42, and what they say at the end, at the very end of 42, is that what is required is for the alternative construction, so this would be my construction, to be realistic as against another realistic construction, and the validity principle is then engaged. Now, if there's any doubt, as I say, then that provides the answer from a contractual interpretation point, the court should seek, in accordance with all the authorities, which will be well known to the court, should seek to uphold rather than defeat the party's contract. 2 more points, if I may, before turning to issue 3. First of all, what was said in the skeleton of the appellant's end orally was, well, really, this is just another contingency. And the Supreme Court in Packard said, don't worry about contingencies. That's missing the point, missing the point of my submission. And we've said this in our skeleton at paragraph 77. What matters here is not the mere fact that it's a contingency in and of itself, but it's the substantive nature of the contingency. Lord Sales isn't to be read in Packard as suggesting that any contingency of any kind makes no difference to any of the analysis about whether a contract's a DBA. He was looking at a particular contingency and said that one doesn't change the analysis. Here, we're talking about a contingency that says the clause is just not at all enforceable. Or rather, if it's not enforceable, then it doesn't operate, or it only operates to the extent enforceable. So it's a substantive. We don't rely on form. We rely on substance. Finally, in their skeleton and orally, the appellants make some broad appeal to public policy. Firstly, they cite no authority in support of the proposition they advance at all. Point we noted in the skeleton, still no authority today. No authority to support the proposition that you can just discard the obvious and clear and natural reading of these words because you might not like them. I mean, in fact, the policy argument itself goes nowhere, but there's no authority cited in support. Secondly, I just draw your attention, my lords, to the fact that a number of points were taken in their skeleton which we've dealt with one by one in ours. The position has moved on orally a little bit, and the way it's been put now is that there's an incentive to act in a particular way now when the law...
That I think is, as I understood it, that's what's said to be contrary to public policy. It's the incentivisation, as my lord put it, of a greater level of risk, something of that kind.
I just make a few points in response, briefly. The first point to note is that when the Supreme Court, I'll make this point broadly, but it's, in my submission, supported by a close reading of the judgment. But in the Supreme Court's decision in Packard, they did not reach the conclusion that litigation funding needed to be regulated because there was some scourge on society or there was some serious mischief that meant that it had to be included. It wasn't a policy-driven decision. It was based on the Supreme Court's view of the correct interpretation of the expressional claims management services. And in fact, what the Supreme Court judgment then does thereafter is explain why they're not persuaded by the policy arguments the other way. And indeed, they went so far as to say they weren't expressing a view at all on the broad policy argument that third-party litigation funding should be available to support claimants so they had access to justice. That's paragraph 90. So we don't come at this question from a position where we're being told by the Supreme Court that you've got to be very vigilant about this problem in civil justice or broader society. Now, the way it's put now is that there's an incentive to act in a particular way and that funders might be improperly incentivized to invest in, I think, the more valuable claims, which notwithstanding that they might be more speculative. First of all, respectfully adopt the observations of my Lord Justice Green of yesterday. No evidence to support the submission that this conditional language is actually going to change how people take decisions. And why would it be any different as compared to the multiples? Funders are naturally going to be looking for cases that support their returns, where there is a prospect, a reasonable prospect of damages sufficient to pay a viable return, and with prospects of actual recovery and enforcement as well. It's got to be said, the argument has to be that additional language is going to make a very significant difference to the way litigation funders act. Why would that be? Why would that be when they're telling us that the multiples could be very high? We know these in this case, these are big cases. We are now talking about these particular cases. The investment by the funder is significant, 10, 20 million pounds or more. We see some of the numbers in the agreements before the court. And the funder is entitled on any view to a return by way of multiple, and in the CICC cases paid in accordance with the priorities agreement. Those are going to be large numbers. The funder is going to want the case to be justifying a substantial value anyway.
One's got to look at the mechanism by which the incentive, the risk profile might increase. If you're an investor, on one basis, you invest on the basis of the law as it is today. And if that investment analysis works out in favour of investing, you do so. You can hedge against the possibility that the situation might become better by putting in a clause. But then the question is the risk profile increased because you say, I'm not going to invest upon the basis of the law as it is moment, and I'm going to take a 15% risk that actually the law gets better, in which case the law improves and I do even better. That's the thing I have difficulty with, without some evidence that that's the way investors think, or that Parliament thinks that that is a risk worth eventuating against.
I respectfully agree, if I may say so, but also it's just counterintuitive. Why would that move the dial so significantly in what are substantial claims, where the investment is already substantial, the multipliers provide for a particular return? Why is that going to move the dial? Because it's the marginal difference in the behaviour of the funder that we're talking about here. The funder's already going to be wanting to achieve, or put itself in a position where
it's not just that, one's got to get to a level where public policy changes.
Exactly, that was my next point.
In my own head, I'm trying to find out how many steps you have to go through.
It's not just got to move the dial, it's got to move the dial so significantly that this becomes a problem of public policy, sufficient as to ignore the true and obvious language of the clause and reach the stark conclusion that these contracts are unenforceable. That's the submission that's being made. But the difference that language creates is it will influence the funder's behaviour so significantly that it's completely unacceptable. Not a good submission. Now, there are also some other obvious points which will affect the funder's behaviour if one is to go down this rabbit. First of all,
well, you could say, I mean, I suppose the argument seems to be something along these lines. I mean, on the incentivisation, without this sort of saving contingency provision, the terms on which the funders were being prepared to fund as regards the multiples would have been more disadvantageous to the class representative, but there's simply no evidence of that at all. And in any event, I think I've certainly seen somewhere, and I mentioned this yesterday, that the irony of all of this debate is that actually
it'd be more alive.
Actually, the outlay route is more advantageous to the funders than the percentage route.
It can be.
It could be. Could very well, and one can see the situations it might very well be, particularly if the litigation goes on as Merrick's did for years and years and years.
And I'm coming on to a point actually that the recent Merrick's decision touches on, but that's absolutely right. And the reality is, again, coming back to the situation we're actually faced with, the parties have been willing to enter into this contract in the knowledge that those other clauses might never come to be engaged. So the suggestion again that the funder's behaving in a particular way, well, the funder goes into these contracts knowing those clauses might never be enforceable if the appellants are right that they are not in fact enforceable, and is prepared to contract on the alternative terms found there anyway. There is also the other obvious point, which is that if these clauses never come to be engaged, then the funder will never get the additional return. I know that might not stop what Mr. Pitchinen says is the ex ante, the prior incentive But nevertheless, the fund goes into this knowing I may never get this. Well, how does that affect? That's a reverse incentive, one would have thought. Again, we don't know exactly how that operates on the funders' minds because we don't have evidence, but one would have thought it would.
How many of these contracts have severance clauses in them? I noticed that some do.
I don't want to misspeak. I know that Neill and CICC opt-in do. I think the others do also, but I'd have to double check. And I'll show you the clause in Neill, which is particularly striking.
But it only matters in
It only matters in
CICC
those
opt-in and Neill.
It does. Now, and final point, two final points. I was criticised by Mr. Justice Jacobs in a recent trial for having 7, I think, final points. It's always an advocate's error, or maybe it's my error.
But I actually took up the Neill contract 37.4, which says that if that clause is unenforceable, it is deemed severable, and both parties agree to that.
And it's the Tillman requirements that are set out there.
Yeah.
I'll be going to that next in a moment. Two more points, please, on conditional language in issue 2. The first is another practical reality is that the parties can always renegotiate if they so wish. So again, if we're looking at what's operating on the minds of the funder here, well, the funder might be incentivised in a similar way, maybe not quite the same way because it's not already in the contract, I accept that. But there's nothing to stop the funder going into an agreement without this language and thinking, well, if things change and I can have a percentage, then I'm going to try and renegotiate. So that, again, this court can't reach a conclusion that the current position is one that offends against public policy in circumstances where that sort of incentive might be operating anyway. And there's, when you realise that, what's the real harm in including clauses like this to avoid having to renegotiate in future? Final point is that there's a suggestion in the skeleton, and I think underlying this incentive point made orally, that this gives rise to what is described as an elevated conflict of interest or risk of conflict as between funder and class representative. We've dealt with it in writing, but I wanted to add this. The situation here in these 4 cases in the CAT is that there are a number of other safeguards. And I refer here to the discussion of those safeguards of my lords in the Gutmann decision of a few weeks ago. You'll be well familiar with it. If I can provide you with the references, it's tab authorities file 2 tab 28, and the paragraphs I rely upon are 7 to 9 and 100. But let me make the point, so 7 to 9 and 100. What are the safeguards that mean that public policy need not be troubled by this at all? First, the CAT will only certify the claim if it is satisfied that there is a suitable class rep who will act in the best interests of the class. Second, that there is included in the LFA language which prohibits the funder from exercising control. And you will find, as in Gutmann, such clauses in CICC opt-in LFA and the Neill LFA. Let me provide you with the references. I don't propose to go to them given the time. CICC opt-in, supplemental bundle A5, page 67, clauses 6.2a and b, Neill LFA, supplemental bundle C3, page 370, clause 4, which requires the funder to act in good faith, that's 411, and to abide by the Code of Litigation Funders, 4.3, which prohibits funders from seeking to control litigation. So it's elevated, that code is elevated to a contractual obligation.
Yeah.
Which also you see in some of the other LFAs, Kent, for
Yeah.
example. And of course the final safeguard that arises is that the funder will be aware of the CAT's supervisory jurisdiction to control what gets paid out in the final reckoning. Again, if that's not going to check this supposedly impermissible incentive, I don't know what is. So there is no elevated risk of conflict of interest, no risk of harm to consumers or parties or a competition appeal tribunal or civil justice or some other intolerable harm that's threatened.
Yeah.
Now I've got to deal with issue 3. We could break for a short moment now, or I can carry on and we could break after I've dealt with issue 3.
So let's get issue 3 out of the way and then we'll have the 5-minute break then.
Now issue 3, so structure of this, arises only in the event that I am wrong on issue 2. So I've won on issue 1, but I've lost on issue 2. So now, the fallback argument on my side of the court is if you're not with me on that language, not engaging 58.3a2, then you can sever it. Or, as we say, apply the approach adopted by Lord Justice Lewison in Zuberi, which is to say, well, that's the only bit that's unenforceable. Now, I'm operating here on that assumption that all else being equal, the relevant agreements are DBAs, which, as you know, for reasons Mr. Bacon has mentioned and which I've alluded to in the context of ATE, we don't accept. But let's proceed on that working assumption. My first point is that one has to locate within the contract the provision which amounts to the DBA, and it is only that aspect of the contract which is unenforceable, and the rest is fully valid and enforceable. And that is the clear approach of this court in Zuberi. The second argument, which I take in the alternative, is that if I'm wrong on that, then you can sever what is said to be the problematic language, leaving the remainder valid and enforceable. Now, a point of order, strictly speaking, severance arises only in Neill. It wasn't taken in CICC opt-in. You asked a question about this yesterday, my lord.
Yeah.
Because the opt-in agreements were only in draft, and as I understand it, the position was that if there was a problem with the conditional language, they could amend the draft. So they didn't need to get into severance to save the contract, because the contract was as yet unexecuted. I'm also told, and again, I didn't appear below, but there were many points to deal with in a short period of time. But what I would say, and I accept that it's not expressly raised, but the same reasoning would, in theory, apply. Now, let me deal first with the first argument, which is how Zuberi should probably be understood. You have to locate the DBA within the contract, and it is only that part of the contract that if non-compliant is unenforceable, or in the context of opt-out is always unenforceable. And here, that's only this conditional language, the language to the extent enforceable or permitted by law, a percentage payment. And that is because the hypothesis we're in is that we've won on issue 1. Nothing else offends, nothing else is a DBA in all of these contracts.
Yeah.
Now, we looked at Zuberi through the lens of Ms. Sarathi's excellent submissions yesterday. Could I ask that we turn it up again, please? It's Authorities Bundle, File 2, Tab 19, page 839. I'm going to go to start. 839 is the front page. Actually, I'm sorry. I think I was going to refer to the weekly's version, but I think yesterday you referred to
Yeah, I was going to say
why
that.
don't I use the same version as you were referred to yesterday?
I don't know why there are two in the bundle, but
I think Ms. Sarathi explained that one was supposed to be the
Meant to be
first
the High
instance.
Court, was it, or the
I'm
lower
not sure
court?
why we're being referred to the High Court. Anyway, there we are. Not to worry.
But I'm afraid I didn't realise the error until today.
Okay, so in the weeklies.
So are you happy for me to look at it in the weekly's version? I think you may have looked at the version at tab 20 yesterday.
Well, we've got the paragraph numbers anyway, so.
Yeah.
Very well. Well, I'll look at the version in the weekly's. That's the one I've marked up. Paragraph, please, 33 and 34. It's page 871. Now, I should say, obviously, I accept. In fact, no. Now I'm confusing my numbering. Page 847. Now, Ms. Sarathi suggested that this case is different. Obviously, the case before you is not exactly the same as Zuberi.
No.
Otherwise, it would have been decided, and we wouldn't be arguing. But the distinction is immaterial. When you look at what Lord Justice Lewison was saying, his reasoning applies squarely to these cases. So at 33, two possible views of what the DBA consists of. One view is, if there is a provision which entitles the lawyer to a share of recoveries, then the whole of the contract retains DBA. Another view is that if a contract of retainer contains a provision which entitles the lawyer to a share, it also contains other provisions which provide, my emphasis, for payment on a different basis. Or other terms, which don't deal with payment, only those provisions in the contract of retainment which deal with payment out of recoveries amount to the DBA. And he says he prefers the latter view. And Lord Justice Coulson at 77 agrees. Now, when you're reading those passages, there was in my learned friend, the appellant skeleton, they sought to rely on Lord Justice Lewison's references to a share of recoveries as suggesting that DBAs are broader. That wasn't developed, that wasn't developed orally. But the point I make when you're reading these passages is this. When he's talking about payment out of recoveries as being the DBA, what we're talking about here is those condition clauses being the DBA. Because ex hypothesi, nothing else in these agreements you would have decided under issue 1 is a DBA. That is a very important starting point. And when you realise that when Lord Justice Lewison is talking about payment out of recoveries, the equivalent here is the conditional language which provides for a percentage. That is the bit which would be the DBA. In the assumed world we're operating in issue 3. Nothing else in the contract. It follows necessarily from the assumed conclusion on issue 1 that nothing else in the contract is a DBA. Only the conditional language, because that's the bit that's under attack now. They've lost on issue 1, they try to win by other means in Neill and CICC, they attack the conditional language. They say that's a DBA. Nothing else is. So when Lord Justice Lewison is saying prefer the latter view, the only way to read that in these cases is, okay, that language, if I'm wrong on issue 2, that language somehow bites, notwithstanding the conditional language, somehow bites, that is the equivalent of the payment out of recoveries, that is the DBA. And that, and only that, is the DBA. And that is what Lord Justice Lewison is saying here in terms. And it's that with which Lord Justice Coulson agrees. Now that is crucial because when you realise that, it follows necessarily that the remainder of the contract is enforceable and permissible without more, in exactly the same way as was found in Zuberi. The termination provisions, which provided for a different form of payment, were not the DBA, and they carried on. And I would add,
Is my memory right that in Zuberi, the contract had was 2 different clauses for payment which applied in 2 different circumstances. One was effectively, I'm going to say, the end of the proceedings, and the other one was if it settled early.
well, if the contract was terminated.
Terminated, forgive me, yes, thank you. And it was what the outcome of that case was that this terminated early provision was found not to be a DBA, and therefore, and it was valid and it applied. The bit that would have been a DBA is if the contract had run all the way to the end, and that would still have been a DBA.
Yes.
That's just not what happened.
Yes.
So these weren't 2 clauses that would both apply at the same time on with some condition that said if it's lawful do it this way, if it's not lawful do it that
Well,
way.
that's
It. These is effectively almost like 2 contracts welded into one.
Well, I mean, that's the submission I made earlier, that I'm not suggesting it's exactly the same.
No, I understand that, I get that. I'm just
I
trying to remember what it
recognise that.
was.
I recognise that.
Yeah.
But what I'm interested in is the principle that arises out of this case. And you will note, and I'll come back to this when I deal with severance in a moment, but Lord Justice Lewison expressed the view at 7 that he felt it would have been severable. Had the clause been problematic, had he not reached this conclusion through the first route, he'd have found it was readily severable. He did not suggest that those requirements were cumulative, that you needed to both show that it was not the DBA, and then you could apply severance, which is the submission that's being made. It's being said, I need to establish that only part of it is the DBA, and I need to meet the requirements for severance. That's not the approach Lord Justice Lewison took. He took the view that those were alternative approaches, And that once you've located on his favoured approach, once you've located the DBA, that's the bit that you would, in this context, conclude is unenforceable, because of section 47C, because it's opt-out, or because of non-compliance with regulations. And the rest lives without any difficulty. And that's the effect of 33 and 34. And it's entirely consistent with the broader point that litigation funding was lawful prior to the DBA regs. And there's no reason why Parliament intended to regulate this in this way. Now, if we read down to 38, it's the same point I was making, but I just draw your attention to the words right at the end of 38 against the letter G. I can see no objection to regarding that part of the overall agreement relating to recoveries, rather than the whole of the contract of retainer as amounting to the DBA. In our case, that should be read, I see no objection regarding that part of the agreement, the conditional language, as amounting to the DBA. In those circumstances, the effective regulation would control that part of the contract of retainer which dealt with that, but not the rest. And the rest is fine. You don't need to sever. And I've mentioned Lord Justice Coulson agrees, that's 77, and in my submission that is binding authority on this court on the principles to be applied. We're not confusing or conflating two different things. The only bit that is unenforceable, and it's the clear language of section 58AA sub 1 and sub 2, it's the DBA. In the language of the statute, the damages-based agreement is unenforceable. And according to the approach of the Court of Appeal in Zuberi, the DBA is only the conditional language. And if you're applying section 58, we can pull it up, Authorities Bundle 1, page 27. Authorities Bundle 1, page 27, sub is 58AA2. A damages-based agreement which does not satisfy the conditions is doesn't say anything about the rest. It's only the DBA. And 47C8 is in similar terms. It's the damages-based agreement that is unenforceable. And we're told here how to identify. We're told by Lord Justice Lewison how to identify what that is. And statute does not bar the rest. And in my submission, the only way of reading Zuberi with 58AA2 and 47C8 is that there is only one bit that is unenforceable, and the rest is completely unaffected. So we've not made any errors here. It's the appellants who are, we say, respectfully confused. They say that the starting point is that the whole agreement is unenforceable because of this language, and you have to sever. No, the statute tells you, read with Zuberi, it's only that bit that is unenforceable. Now, let me just deal finally on this point with the argument made by reference to an example. My learned friend Mr. Rathi said, imagine a situation where the client agrees to pay a solicitor 70% of the damages. Unenforceable because it's more than 50%, which is what's allowed under the regs. She says on our case, the clause is unenforceable, but the rest of the contract lives on. And we've got an absurd situation where the solicitor has to work for free. And she says that demonstrates that our analysis is flawed. I'm afraid that's just wrong, with all due respect, as a matter of contract law. The correct answer is that you don't end up with an absurd situation, or indeed with an effective contract in that example, because of the intervention of an altogether different contractual doctrine at a different stage of the analysis, which is consideration. Absent that clause, there would be no consideration moving from the client. So the contract as a whole fails, not for reasons related to Zuberi or Severance. And so if that's the example that's deployed to test our position, and it actually shows that there's no flaw in the analysis.
So does this conditional clause work as consideration?
I might put that in the too complicated for my tiny mind at 20 past 3 on a
Yes.
Wednesday afternoon. if I respect.
It's
I
relevant.
think what might be said is it does work as consideration, which is why it's unlawful. Because it is part of the
Well,
contract and it's
well,
it operates. It's operative. That's why it is consideration.
It's, but if it's not operative, if it's not lawful.
If it's not consideration, how can it work? How can it do anything?
Well, it's a
It's a
no,
comparison
I
with
don't
a
agree with that
situation where
premise,
there
if I
isn't
may.
an alternative consideration.
It's alternative. First of all, clause doesn't have to be consideration to be effective. I would
Okay.
respectfully submit. So I'm respectfully not
Is
sure I
it the
agree
other
with
way
the
round?
premise.
No.
But it's alternative. It's consideration that would be payable in the event that it's lawful to pay it. Nothing more, nothing less. And so we don't need severance. And I respectfully repeat that Lord Justice Lewison did not suggest, and he didn't seem to think that we needed both. Now, can I just, before moving on to the severance point proper, can I just show you one other paragraph in Zuberi, which actually goes to issue 1, but I just don't want you to miss this. It's at page 856 of the weeklies. I'm sorry, 853. And back in the authorities at tab 19.
Yeah.
Paragraph 56. I just wanted to show you this. We are here in the judgment of Lord Justice Newey. If you turn the page to 851, you can see that we're in the judgment of Lord Justice Newey.
Mm-hmm.
The subheading is some more history. So in the event that my lords wanted some more history, you can find it here. And he refers here in the context of the bringing into force of the 2010 regulations. And I raise this because it's my learned friend Mr. Piccini's submissions were very much directed at look at the world in 2009 and 2010 and the employment context. Well, even if we limit ourselves to that context, the then minister in the Lords, Lord Buck, said this when in the context of the House of Lords approving the regulations. A damages-based agreement is a type of contingency or no-win, no-fee under which a representative agrees to act for a client in return for a percentage of any damages. And then he says, these agreements are, of course, different from conditional fee agreements. So if you needed more material of that nature, it's found there. I'm now going to finish off my submissions by dealing with severance proper.
Mm-hmm.
And here, my lords, the starting point is the decision of the Supreme Court in Egon, Zender and Tillman. My lords, as you know, that was a case involving wording in a course termination restrictive covenant about whether the employee was prohibited from being interested in a competitive business for a period of time after her employment with the first business had ceased. The question was, does that prohibit her taking a shareholding? If so, is it unreasonable as a restraint of trade? And if so, if it is unenforceable because it's unreasonable, is it severable? And the Supreme Court held that the language did prohibit the acquisition of a shareholding, thus was unreasonable and unenforceable. But it concluded it was capable of being severed so as to leave the rest of the covenants and indeed the contract live. And the Supreme Court dealt with the key principles there and that they're common ground for these purposes. I know that were the matter to go forward, there might be arguments about whether the nature of the test set out by the Supreme Court in Egon Zender should be relaxed outside of the employment context. Because Lord Wilson, when giving the judgment of the court, made it clear that he thought that caution needed to be exercised when severing clauses that employers had put into employment contracts, because it allows employers to chance their arm at something very onerous and then get away with it something lesser if it proves unenforceable.
Mm.
Let's put that to one side, and for present purposes, I'll work from the tripartite test. First of all, the blue pencil test. Not disputed that it's satisfied. No dispute about the blue pencil test. I always thought, for what it's worth, it should be the red pencil test. My school notebooks are always covered in red pen, not blue, but there it is. Secondly,
There's some reason why it's a blue pencil test, and I can't now for the life of me remember why. But to a lawyer, I agree. You'd have thought it might be better to have a red pencil test. But there we are.
In S7 Harper's Garage. The House of Lords in S7 Harper's Garage in the
Is
70s.
that what it was?
Yes, could be. Could have been.
Could be, yeah.
I'm glad, my lord, you engaged with my
Yeah,
comment, because
blue
I was
ink
worried
now,
I was going to be met with total silence. Second requirement continues that the contract continues to be supported by adequate consideration. Again, not disputed that it's satisfied here. Third, that the removal does not affect a major change in the character of the contract. Now, first of all, as we've noted in our skeleton in Zuberi, paragraphs 7 and 8, Lord Justice Lewison took the view in that case that the contract could be severed. It was obiter. The point wasn't debated. It was only my learned friend Mr. Bacon, acting for the Bar Council as an intervener, that raised the point. Nevertheless, Lord Justice Lewison's view was clear, and he expressed it in clear terms, that the relevant provisions in that case were capable of severance. Now, in my submission, this case is an even more compelling one for severance than Zuberi. And in this regard, major change means major change. In Egon Zender, the Supreme Court overruled the previous appellate position in Apt that the change could be no more than trivial. It is a much more flexible test than that. There is no major change here for several reasons. First, we're talking about severance of provisions which, as the law currently stands, the appellants say are not effective anyway. Not effective anyway. Secondly, they don't significantly alter the commercial rationale of the contract, the nature of the contract, or the nature of the bargain struck. And here the language of Lord Justice Lewison at 7 in Zuberi about not the sort of contract the parties entered into at all is highly material. And you see that language also in Egon Zender. The parties are and were plainly willing to contract on the assumption that this conditional language may never be in play. They've drafted in alternative provisions, which you've seen, which they are plainly content to abide by and to be bound by. The fact that there's an alternative arrangement doesn't change that. The appellants then say, orally and in writing at 96 of their skeleton, well, the fact they wanted these clauses in shows their importance. Well, that, with respect, is circular. Yes, they've obviously included it as a possibility, but the mere fact it's there does not mean that were it to be deleted, that would have a major effect on the contract. Otherwise, if it were otherwise, the mere existence of language in the contract. Now, the situation here is much closer to Zuberi, and I say indeed more clear-cut than Zuberi, nothing like Volterra. I just want to pick up on Volterra. I'll make these points briskly, but if I'm going too fast again, you'll no doubt let me know my notes. The position in Volterra was, and you'll see there's a quote from Volterra at paragraph 97 of the appellant skeleton, which is all about how it goes from being an agreement with an element of, well, a very significant component of conditionality to one with none. So that is a radical transformation. There's no realistic comparison between that case and this case. And if we now pick up Volterra, please, Authorities, tab 26, page 1091. Paragraph 30, and page 1092 now. Paragraph 30. Lord Justice Stuart Smith uses the expression over the page at the top of 1093. Is it essentially the same sort of contract? And he's asking, the question is directed to the substance here. It's not directed to nomenclature or labeling. It's directed to substance. And that's squarely applicable here. It is plainly the same sort of contract, essentially. And it is about whether it changes the overall character of the contract as a whole. And you can see that if we turn the page to 1095, paragraph 36, towards the bottom of the paragraph, there's a sentence that starts, however. And it's all about the character of the contract as a whole. Here, the funder is still going to be funding. None of the funder's obligations change. It will only get a return in the event of success. It will be paid out of the proceeds, and it will be subject to the review by the tribunal. And it will be entitled to capital outlay back and a return. None of that changes. The nature of the agreement remains the same. It's an agreement pursuant to which the funder agrees to fund the claims in exchange for its money back plus a return in the event of a successful outcome. Now, in Volterra, the solicitors sought to rely on Zuberi. That attempted reliance was rejected. And we can turn up here the reason why, if we pick it up at paragraph 53, I'll come on to the public policy point separately.
Yes, sir.
But at paragraph 53, Lord Justice Stuart Smith says this. He says, and I'm in the middle of the paragraph, I accept the client's submission. The discounted fee provisions which the solicitors seek to enforce are part of the core agreement that make the September 2017 agreement a CFA. Do you see that passage, my lords?
Yeah.
It's radically different here. I've just explained how the starting point here is that the provisions that we seek to enforce are not the DBA. They're all the provisions that this court under issue 1 would ex hypothesi have held are lawful and permissible and not a DBA. It's completely different to Volterra. Now, and instead the analogy with Zuberi is close because it's an alternative form of payment, an alternative mechanism for calculating payment. I agree with my Lord Justice Burst, it's not exactly the same, obviously.
Yeah.
But it's another payment provision. And can I just now finish on the major change point by going back to the clause that my Lord Justice Green identified earlier in the Neill LFA, which I don't think we've looked at so far together. It's back in the supplemental documents bundle, C3, page 389. Page 389, supplemental documents, and it's clause 37, headed Severance, at the bottom of the page. My lord, let me know, perhaps you could let me know how to read that.
Sorry, page?
389.
Thank you.
Thinking back to cases, early days of competition law, the cases where courts wouldn't sever were generally where, on restraint of trade, you had a geographical limit was you can't compete within 10 miles. Court said it was unenforceable, but would not rewrite to make it 5 or 4. Or you can't compete for 6 years after termination. And it might have been that 3 or 4 was reasonable. Court won't rewrite because the court were not constitutionally improper for us to write somebody's contract. Those are the sorts of cases where the courts strike down the contract.
It is, my lord, and that's right, first of all. Second of all, it engages a different question, which is whether that should be the test for severance. And in Egon Zender, the Supreme Court noted that the limit of the blue pencil test, blue pen test, to the effect that you could only delete language but not add or modify, was arbitrary, had the effect of achieving capricious outcomes, but in the particular context of employment, was nevertheless justified as what they described as a break on the principle. And that's the point that I say, well, in other contexts, not this case because it's conceded here that the blue pencil test applies, but it might be said, well, in other contexts, one need not be so harsh. But I respectfully agree that that is generally the situations one sees where the severance is
The rewriting is the converse of the striking out. You strike out and you then see what's left. And you can't say, well, what's left is fine because I'll rewrite.
No, you can't do that.
But in a case such as this, it may be inelegant, it may be what's left is clumsy. But
If it's workable,
it's workable.
And I would say, with respect, there's no clumsiness at all here. If you draw a line through the condition enforceability language, the contract is perfectly fine. There's no difficulty. It's not even one of those cases where I'm having to slightly apologise to the court for the fact that one has to be a bit inelegant in the way one reads it. It reads perfectly.
Yeah.
Fleeting memory of a point arising in those sort of ex-employee competition cases in which you'd have a contract which would have options. In other words, you'd say 6 miles, A 2 miles, 3, 4 miles, and I don't remember those being very favourably looked at.
No.
Isn't that a bit like what you're trying to do?
I don't think so, man.
You can say that.
There's a surprise.
But you see, if you think about these employment contracts, you could write language like the language you've got. Say, oh, don't worry, Judge, where it says light year, it says if only enforceable.
Well,
I can't really work.
I think it's fact and degree, really.
Okay.
I can't say I've done a full review of the case law in employment cases as to what was.
I understand that, but
but
I just wonder whether there's a point.
There
This
may
is a
be-
wider
there-
issue.
there
Just
may
forgive
be
me
a-
just a second, Mr. Chancellor. There's a wider issue here about just writing words into contracts that say conditional if it's okay. If it's okay to, if only this illegal clause was legal, I'd have this clause.
Well,
That's not a specific issue for this facts of this case. It's a general point.
I don't disagree with the point expressed at that level of direct generality. In the sense that there may be at the outer edges public policy creeping in, and in Egon's Ender, public policy was an important feature because the Supreme Court noted in that particular context that freedom of contract, I think they described it as one of the principles that this country was built on, is what was said. And so when the court, to come back to the way my lord put it, and when I used the expression at a level of generality, that wasn't a criticism. It must be right that there will be outer limits to these exercises to be assessed. And I'll come on to the public policy points in a moment. I'm conscious of time, but one has to look at what the public policy is, the extent to which the clause makes an inroad into that public policy, and a question of proportionality. And in the employment context, when in circumstances where the Supreme Court has on a number of occasions, but most lately in Tillman, said, be careful, because freedom of contract is very important and employers shouldn't be allowed to do precisely what my lord has suggested, then you may adopt a more harsh approach. It may not be on the major change criterion. It may be on some other basis, because of course what I'm addressing you on the moment is major change. It may be on a public policy basis that the court interferes. I'm not suggesting that's never possible.
The alternative way of looking at this legality point is that the funding is option A, but if the purchaser's bank does X, then it's option B, which is more favourable to the funder. Here we have, if Parliament does B, then another option arises. So it's it's a contingent event. It's not, doesn't turn upon what the court thinks about the legality or otherwise of the clause.
No. And I think, as was explored in submissions with my learned from Mr. Fitchin yesterday, if Parliament legislates or Supreme Court reverses the effect of Packard or something of that nature, then by definition there won't be a public policy problem. I was just going to show you these clauses 37. You'll see there's the general severance clause at 37.1, and then at 37.4, and I rely on all of these, at 37.4 there is an express severance clause relating to this language, where the parties agree, effectively giving rise to a contractual agreement, and indeed a contractual estoppel, that it's severable. And the point I make by reference to the severance clause is that it should, if the court, again, I say there's no doubt on the major change criteria, but when you're asking yourself what the parties intended, and whether the language, the subject of the proposed severance would, were it to be severed, result in a major change, we can see here that the parties have expressly agreed that such severance does not change the nature of the contract. They've actually agreed in express terms that all of the requirements for severance, including that there's no major change, are met. And were the court, I make this broader submission on the basis of the clause, were the court to have any reservations about that for first principles, the clause should be an additional factor which tilts the balance. Again, that respects the party's freedom of contract, and it's very clearly what they intend here. I note for completeness that in CICC there is a severance clause. It's not in the same terms, it doesn't refer to the Tillman test, but there is a severance clause that includes the priorities agreement. And in CICC opt-in, you'll find it at clause 11.3. Finally, and this is my final topic, public policy. It is said here that severance not permitted unless accords with public policy. This picks up on the exchange I just had with my Lord Justice Burse. The way it was put in the skeleton is that public policy does not require severance. We don't say that public policy requires severance. We say that public policy does not bar severance. My starting point here is that there is very little room at all for considerations of public policy when considering severance. Certainly in this case, public policy is not part of the tripartite test you find in Egon Zender. It is not part of the, it is not a fourth limb of the test. It doesn't find expression in Lord Justice Lewison's summary in Lex Law and Zuberi, which follows Egon Zender. And so the authority relied upon by my learned friends in their skeleton was a passage from Chitty. And we noted that when you look at that passage, which is in Authorities File 2, worth looking up quickly, tab D, right at the back, page 1403. This is the latest version of Chitty. The quote in my learned friend, the appellant skeleton, was from the 34th edition. We found the paragraph in the 35th current edition. It's page 1403, the Authorities File 2.
Yeah.
The court will not sever the bad from the good unless this accords with public policy. For example, examples are given, there's a quote, in all the cases a distinction is taken between a merely void and an illegal consideration. In this context, illegal means that which amounts to a criminal offence or is contra bonus mores, where on grounds of public policy the illegality may, though does not invariably preclude severance. So even if you're illegal or contra bonus mores, that doesn't necessarily preclude severance. In the examples given up, agreements to defraud the revenue, all which involve trading with the enemy. Now, I should add that the very latest edition of Chitty has a footnote also to Volterra here. Now, the present case is very far from those examples. It's not a criminal situation of criminality, nor indeed is it a case of contra bonus mores, which is a high bar. It's a case of unenforceability. Nothing more. That is the language of the statute, unenforceable.
There was a lot of case law on this distinction in competition law back in the 90s about whether or not something which was a restriction and competition law was just merely unenforceable or was illegal as being contrary to public policy. But this is quite clear. The statute says it's unenforceable. So it's not an illegal or an offence to enter into the contract. It just means the courts won't lend their assistance to its enforcement.
Yeah.
Exactly.
And that's the important distinction.
It's an important distinction. And indeed, we make the broader point here, but there's nothing unlawful per se, about LFAs. See Arkin, which is in the bundles, Chapelgate, all the other recent cases. Nothing improper or contra bonus mores about a litigation of agreement per se. So we say public policy does not come into this. Now, I note that in Egon Zender, as I mentioned earlier, the court noted how powerful the public policy considerations were in that case. You only have to look at paragraphs 22 to 29, where they describe it, the policy of freedom of contract against restraint of trade, as one of the earliest products of the common law, and as being of central importance, a weighty doctrine. But it didn't preclude severance even in that case. This case is,
Contracts and restraint of trade are equally, they're not illegal, they're unenforceable.
that's true.
Like gambling contracts, they're not illegal, they're unenforceable.
That's true.
Yeah.
But if it wasn't problematic in Eons Ender,
Yeah.
this case is a fortiori. That leaves it.
Where does public policy comes in? Public policy comes into telling you can't have such and such a clause. Once that's severed, there's nothing wrong with the rest. So provided it survives in contract law terms, there's no reason of public policy why that should
Exactly.
fall. Because you've already taken the public policy bit out.
Exactly. There is no problem with the LFA in the hypothetically severed form here at all. There's no, if we want an issue on it, it's not a DBA, there's no problem. Now,
Isn't there something slightly odd about this unenforceability point? Of course, it's absolutely right that section 47C8 says that a damages-based agreement is unenforceable in an opt-out case. And on my lord's point, one might say that all that means is a court would never enforce it. Quite what's going on in these circumstances when you've got the CAT supervisory jurisdiction. I venture to think that the CAT wouldn't certify a case in which the funding agreement was unenforceable, even though the only real legal consequence of unenforceability was the court wouldn't enforce it. So it's not actually a complete analysis of the circumstances to simply focus on the word unenforceable and say, oh, don't worry about that, it's just unenforceable.
I do.
Right.
Let me take that in stages. I agree, and I think we've said in our skeleton as much that at the certification stage, the CAT is going to look at the arrangements, and you would expect it to be uncomfortable with an arrangement which it considers is unenforceable. Indeed, that's the reason why we're here, because it's being said they're unenforceable. So don't certify. So I agree with that. I think the question of severance is a different question. That is a question to be answered by reference to the contractual principles we see in Tillman. And if you can sever, if I'm wrong on my Zuberi point, but you can sever, then the CAT will be comfortable. Now, what we're left with is the appeal to Volterra, where it's right to say that the Court of Appeal, as an alternative to the major change point, it found there would be a major change if you severed, because you're turning a conditional deal into an unconditional. But they said in the alternative they wouldn't sever for public policy reasons. It said it's similar to this. Simple response. This is not the case here. When you look at the references in Volterra to the public policy concern, which so influenced the court, the references are consistently to solicitor-client arrangements and CFAs. And let me make that point good, quickly. I'm conscious of my learned friend's time. I'm conscious of imposing on my lords. But if we pick it up in Volterra, tab 26, we can pick this up at paragraph 21. And it's paragraph 21 at 1088. I draw your attention to the passage right at the end of the quote from Garrett. So, at the start of 21, the court, Lord Justice Stuart Smith refers to the seriousness of financial consequences, says it's not a new submission, refers to Lord Justice Dyson's judgment in Garrett. And at the end of that quote, on the next page, 1089, Parliament considered that the need to safeguard the interests of the clients was so important, and so on. It's language that's very specific to CFAs and solicitors. That's not this case. Zuberi confirms it's different here. One again at 24, over the page, there's the reference to the Marshal of the Rolls' judgment in Sibthorpe on the public policy point. And it's an express reference to agreements involving, and I quote, those who conduct litigation or provide advocacy services. That does not cover funders. Next point, next paragraph, we can forward on. It's throughout here, but we can forward on to 52, page 1100. And you will see Lord Justice Stuart Smith there is noting that the judge at first instance, Foster J, rejected a submission, and he sets out there, Lord Justice Stuart Smith, the judge at first instance reasoning, and look at what is said after the semicolon, and where the judge below rejected the reliance on Zuberi by the solicitors, rejected on the basis that different public policy considerations applied, which tended to favour enforceability in Zuberi, as in this case, and which were not transferable to prescription against continuing to act for a client under a CFA. And at 53, look at the third sentence, or rather the final sentence that starts third. This is Lord Justice Stuart Smith in 53 agreeing with the first instance judge who found that the public policy considerations in CFAs were different to those in Zuberi.
Yeah.
And the sentence that starts third makes that point good. And then that's why you see in his conclusion at 62, page 1103, the decision, the alternative conclusion on public policy grounds is absolutely relating to and confined to CFAs and solicitors. And indeed we see that because at the end of 62, Lord Justice Stuart Smith refers back to Garrett, which I showed you earlier was a solicitor case. And the conflicts of interest that are referred to by Lord Justice Stuart Smith, again, are completely protected against here because of the safeguards I mentioned earlier and which you looked at, my lords, in Gutmann. So the position here is completely different. And the public policy concerns which so influenced the court in Volterra don't arise here. One last point on this. If I'm wrong on all of that, then I do say that the public policy question has to be assessed in context. We've referred in our skeleton to Patel and Mirza. I also refer here to, and we've referred to Hollins and the proportionality. I anticipated that what was going to be said against me is that there's a difference between statutory illegality and contractual. I say that because my learned friends introduced into the supplemental bundle a decision of this court, Okedina, which distinguished between statutory and contractual illegality. But that's a different question. We're not talking about here a claim where someone's trying to sue on an agreement and has been met with an illegality defence. We're at a different stage of the analysis here, where it's being said, well, your contracts are enforceable. Can you sever? We say we can. That's then being met with a public policy response. Now, when you're looking at the public policy consideration at that stage, in my submission, it does have to be applied with a sense of proportion, with due regard to the policy in question, and with regard to the consequences. It precisely as the Supreme Court did in Patel and Mirza. I say that for completeness, but that is the only principled and fair way to go about this. My lords, those are my submissions. I'm conscious that Mr. Bacon, I think, has one or two very short further points to make, unless I can assist you further.
Okay. Well, what
I'm sorry. It's going to have to be quick at the beginning of pitching and the Chancellor respond.
I mean, how long has Mr. Pitching been given to reply?
I need about half an hour, hopefully a little bit less.
Well, I think we're going to break for 5 minutes. If I'd known this was going to go on so long, I would have broken.
I'm sorry, my lord, my fault.
All rise.
Just to answer a question which I think I missed from just the nurse about the CFA thing. Well, that's all it is. I just want to I don't like leaving the whole thing. I haven't answered the question.
No,
I'd rather answer the question and say you're wrong. Yeah. Feel slightly anxious that I haven't addressed it. That's all. He wants half an hour, so he just said 25 minutes.
Can you fill in? Court, rise the table.
No, please, Your Honour, just three quick points, and Mr. Pincini has gratefully given way, and I thank you for that. I will be very quick. I wanted to deal with 3 points. The first is to give the reference relating to the permission to appeal point and the context of PACAR. So core bundle, page 167 and 168. In fact, we'll just turn to 168. It's important in the context of understanding what the Supreme Court was determining. So 167 is the start of it, which is analysis of section 49(1)(a) of the Competition Act, which restricts the nature of the appeals that can be brought to appeals under which there is a
Which bundle are we in?
core bundle
Yes.
167.
Page 167.
Correct, yes. So the statutory provision I referred to earlier, without giving the reference, was section 49(1)(a).
Oh yeah, you got you.
Yep. In the McLaren case, Lord Justice Popplewell summarised the position in paragraph 5. And over the page, at subparagraph 6, referred to PACAR as an example of the latter. And in paragraph 6, the tribunal in the Neill case says the reference to PACAR in the last subparagraph is to the judgment of Lord Justice Henderson in PACAR, that's a Court of Appeal, in which the Court of Appeal decided that an issue about the enforceability of funding arrangements was not a decision, quotes, as to damages, and therefore was not subject to the appeal jurisdiction. Crucially, however, in that case, the tribunal had found that there were alternatives to the funding arrangements under challenge, and the proceedings would probably continue with some modified funding arrangements. Lord Justice Henderson accepted that logic and based his decision about jurisdiction on that fact. And we'll see how that translates itself into the Supreme Court in a moment. In paragraph 7, there is no such finding in this case, which is why permission to appeal was granted. Now, if you then turn to PACAR, tab 25 of the authorities bundle, the Supreme Court, paragraph 13, letter F, had been told, page 1011 of the authorities bundle, tab 25, letter F, the court was told that if LFAs of this kind, whereby the third-party funders play no active part in the conduct of the litigation, but are remunerated by receiving a share, and that's a percentage, because that is what they were remunerated for, of the compensation recovered. Now, DBAs within the meaning of section 58A, the likely consequence in practice would be that most third-party litigation funding agreements would, by virtue of that provision, be unenforceable as the law currently stands. And that presumably would be because the DBA regulations would require the funder to limit the amount of funding to 50% of the recoveries, and they wouldn't have done that. But it's in the context of a percentage arrangement. When you then tie that in, importantly, to paragraph 98 and 99 of the judgment, it's perfectly clear that the Supreme Court was not saying, or was not working on the basis that the effect of its decision was that LFAs were, all LFAs were DBAs, and therefore funding for opt-out cases wasn't available or permissible. Because the Supreme Court was clearly proceeding on the basis that there's some other way of funding the opt-out cases without offending the section 58 AA 3A2 definition. And the multiple, even if it's subject to the proviso that the multiple is limited to the proceeds, is the alternative, which one, in my submission, can derive from the decision. Because the Supreme Court, Lord Sales was clearly accepting that an arrangement under which the primary contractual entitlement was subject to a proviso that the amount was ultimately determined by the tribunal did not bring it within section 58.3. That's point number one. Point number two, I wanted to ensure that I left court without having answered my Lord Justice Burse's questions to me earlier about CFAs and DBAs and the consequences of the submissions I was making. And I just want to make it clear, if my learned friend's submission is that a multiple, which then attaches to it a proviso that the multiple is payable, but it's ultimately limited by reference to the proceeds or capped by reference to proceeds. His case is that brings you in 58.3A2 and therefore is a DBA. And my argument there was that that would be a rather curious outcome because Parliament had banned the use of DBAs in opt-out proceedings, and whilst at the same time expressing the desirability for the need for funding in opt-out proceedings. That was what I was dealing with. And then my Lord, you asked, you said, don't you mean CFAs? I thought you meant CFAs, and it may have been my fault that I hadn't appreciated the possibility of your intervention, meaning I've got an even better point, which is this, which is if the CFAs in these cases, because they're all pursuant to CFAs except the opt-in DBA case, if, as they are, they limit the success fees and the basic charges to the proceeds through the waterfall processes that Mr. Saul is carefully taking me to, then they too would become DBAs, and in opt-out proceedings would be unlawful. So not only could you not have funding in the opt-out case, but you wouldn't be able to have CFAs in the opt-out regime, which on any view we know from the parliamentary material, was not the intended outcome.
No.
And thirdly, just very quickly, the reason why my Lord, Lord Justice Burse asked me you can't comply with both regimes is primarily Regulation 4, my Lord, of the DBA regulations. Because Regulation 4, which was the problem we had in Zuberi, Regulation 4 provides that you can't charge a client any more than the payment plus expenses. That's all you can charge. And you have to net off the payment by reference to costs that are recovered, that are paid or payable by the opponent. So there are only two things you can charge. One is the payment, and the other is the expenses. It's just impossible to meet that with the CFA section 58(1) arrangements, which entitled the lawyer to charge profit costs, disbursements, expenses, success fees, and all the rest of it. They're just wholly incompatible. That was my, they were my 3 points.
Right, thank you very much, Mr. Bateman.
Yes,
Lords, can I begin just by inquiring how long we have? Because that took a little longer than I was anticipating.
We go to quarter to 5.
I'm very grateful. I hope we won't need all that
Into
time.
injury time, I'm afraid.
You know, I totally understand that. I'd like to begin with issue 1, and I'd like to begin within issue 1 with a point of clarification on my position on what you can and can't have regard to by way of statutory interpretation, which materials you can look at and why. Because Mr. Bacon suggested at various points yesterday that my whole case is based on forcing you to look exclusively at what happened in 2009 and 2010 without being able to look on at 2012 and 2013. And that is not the position in my case. I did submit and I maintain that the right approach is only to look at 2009 and 2010. And that's for the reasons that I gave yesterday by reference to Lord Sale's analysis of similar issues in the context of PACAR. And since that's what we say is that the right approach in law, I thought it right to put that to the court. But actually it doesn't make any difference to the outcome. Because in my submission, you get exactly the same answer if you also look at what happened in 2012 and 2013 and look at the full set of DBA regulations that were made. The reason I say that is that in the 2012 amendments to the Act and the 2013 regulations, Parliament left in place all of the employment provisions, all of the employment litigation regulations that were there in the 2010 regulations, which were still aimed at the very same mischief that they'd been aimed at all along in relation to claims managers in particular. So, and because the definition of a DBA was common to all types of litigation that were regulated under the 2013 regulations, the DBA still needs to be interpreted in a way that gives effect to the regulations that were aimed at curing the mischief in the employment context, in relation to claims managers, for example. So just by way of illustration, the straightforward circumvention that my learned friend's case would open up, whereby you could have a contract that provides for a large cost sum capped at 60% of damages, together with onerous termination provisions, that's still very much as much a problem in 2013 that needs to be dealt with by the 2013 regulations as it was a problem that needed to be dealt with in 2010 by the 2010 regulations. Now, my learned friend Mr. Bacon says, he said today, don't worry about that. You know, everyone is regulated. Solicitors are regulated, claims managers are regulated, everyone's regulated. Nobody's going to do anything that's unfair to any employees with a claim. But with respect, it's not for him, and indeed it's not for anyone in this room to judge whether that's right or not. That judgment has been made. It was made by Parliament and by the Lord Chancellor in enacting the Act and then enacting the regulations in 2010, and that judgment continued into 2012 and 13 when the new regulations were made. So that's my first point. The second point under that same heading as to why I get to the same answer in 2012 and 13 as I do in 2009 and 2010 is that the new regulations that were brought in to cover personal injury and other kinds of litigation in 2013 are all of the same flavour as the regulations that were brought in 2010 for the employment context. It's the same kind of consumer protection mischief that they were aimed at. It's just that the regulations were a bit more forgiving, a bit less onerous than in the employment context, because that they were dealing only with situations where there would be lawyers involved. So there's the same concern arises in terms of Malone and Friends' interpretation, that you could sidestep the personal injury or the wider commercial, the wider civil litigation restrictions by having an agreement that provides for a large sum of costs subject to a cap at 60% of damages. That would evade the clear intention to regulate the percentage of damages that is there in Regulation 4 of the 2013 regulations. So that's why I say it doesn't make a difference whether you look at it from 2009, 2010 or 12, 13. The one thing I do want to make clear, that the ceremony I really do stand on, is that you can't get help from the Competition Act in 2015 for interpreting these regulations or Section 58 AA, and that's for reasons that I'll come back to. So with that clarification out of the way, I want to start by framing in my reply what it is we're looking at here, because there are two types of contracts that are easy and that we all agree on how to classify them. One is a contract that provides only for payment of a multiple of costs. Another is a type of contract that provides only for a payment of, say, a percentage of damages or some calculation done by reference to damages. The first of those is a CFA if it's made by a lawyer, and otherwise it's nothing. And the latter is a DBA, whether it's made by a lawyer or a funder. Those are the easy cases, and those are the paradigm cases that you think about when you're thinking about CFA or DBA regulation. But in this appeal, in my submission, we need to be carefully construing these legislative provisions with two types of hybrid forms of agreement in mind, and of more complex hybrids of those two that I've just outlined. The first type is the one we're actually concerned with here, namely agreements providing for the lesser of a multiple of the cost on the one hand and a share of the spoils on the other. That's one type of hybrid. But the other type of hybrid that you really do need to keep your eye on as well and have a coherent answer for is the opposite, where you have an agreement that provides for the greater of the two. So the payment is whichever is larger out of a multiple of costs or a share of the spoils. And you've seen both types of those agreements in the world. So there's been lots of discussion about the fact that there are lots of CFAs that are capped at a percentage of damages. And then in addition, you saw earlier today the example of the Kent LFA, the original Kent LFA, which provided for a multiple of costs or, if larger, a percentage of damages.
But are any of the LFAs with which we're actually concerned, the amended LFAs, ones where? They can't be, because by definition PACAR's knocked out that.
No, my lord, yes.
No, either ones with where it's multiples alone, or well, they're all ones where it's multiples plus a cap,
That's
either
right.
express or implied.
That's right. Although the Neill one, which is the subject of issue 2, the bit of the language that is subject to the issue 2 issue of, if it turns out to be enforceable, that one is actually the greater of. It's they'll have the multiple.
Leaving aside issue 2 for the moment.
Yes.
Because
So
on issue 2, if you're wrong on issue 2, then it's as I said yesterday, nil and rem, just
yes.
no
No,
effect whatsoever. If we're looking at what's actually of effect in these agreements,
that's right.
What we're grappling with.
And your lordship is right.
Right,
We're concerned with the first category.
Speaking for myself, I have no intention of grappling with anything else.
Well, my lord, the reason why
Apart from anything else, we're absolutely in the territory where, the famous dictum of Lord Justice Mummery in the Wimbledon Common case, never decide a point that doesn't actually arise as part of the ratio of what you have to decide. And if ever there was a case in which this court should be incredibly cautious of going beyond or giving any sort of general guidance or anything of that kind.
My lord, the reason why in my submission that won't do, I'm afraid, is because we're in danger of adopting a construction of the legislation that is incoherent and incapable of being applied. And I'll just explain why I say that's the case, and you can accept it or not, as always. My submission is you need to come up with a construction of the words determined by reference to in section 58, AA3, A2, that works for both of those types of hybrid agreements. Because my learned friends accept that the second one, the greater than one, is a DBA. That's why they've accepted below that the Kent LFA, which was a greater than one, was unlawful. That's why they amended it. And so they say that a greater than one is a DBA, but a lesser than one is not a DBA. That's
DBA because it had it was assessed by reference to the percentage.
Only on one contingency, my lord. It's exactly, structurally, it's exactly the same. What it says is that if the multiple of costs turns out to be larger than the percentage of damages, then you get the multiple of cost and you don't get anything by reference to the damages. All you get is the multiple of costs. And so all of the debate that we had yesterday, all of the submissions that are made by my learned friends about the primary mechanism, you come back to bite in relation to those agreements. You end up saying that it's very difficult to understand.
Is that an agreement before this court?
Well, let's have a look
Is
at
it
it.
before this court on the appeal?
It's common ground that it's unlawful.
Previous agreement, it was
That's right.
decided it was
It's
unlawful, it's not
common
before
ground.
the court.
That's right. It's common ground.
Well, Mr. Pigeon, if as a consequence of what we decide, if we decide against you, you think what we decided is incoherent, you can go and tell the Supreme Court. But what we're not going to do is decide issues we don't have to decide.
My lord,
Can we go on with something we do have to decide?
yes, my lord, the submission that I'm making to you is that we need to come up with an interpretation of the words in section 58AA that is capable of explaining why one thing is lawful and the other thing isn't. I should say our reading of the legislation is very simple, as you know. It's that both types of agreements are both CFAs if they're made by a lawyer and DBAs whether they're made by a lawyer or a claims manager. That's true because they provide for an uplift on costs on one eventuality, and that makes them a CFA with a success fee. And they also provide for a determination of the payment by reference to damages because you get a percentage of the damages in the other eventuality. And we say that that means you need to comply with both sets of regulations, both the CFA regulations and the DBA regulations. And we say that there's no unfathomable mess here. Rather, what that leaves you with is Parliament's intentions and the Lord Chancellor's regulations applying in the way they're supposed to. The multiples bit, the multiples of costs is regulated. It's subject to the cap of 100%, which my learned friend showed you that applies in relation to CFAs. And the percentage of damages is regulated. That's subject to the cap of 50% or 25% or 35%, depending on the case. So we say that there's no difficulty in complying with both the CFA regulations and the DBA regulations. The difficulty only arises when you say that they're mutually exclusive and only one, and this is the submission that has been put to you by my learned friends, that the two regimes are mutually exclusive, and so an agreement can only be subject to the CFA regulations or the DBA regulations and not both. The difficulty is that it becomes impossible to say why an agreement which has features of both types in it falls into one box and not the other. It's just impossible to say. And so I'm afraid that doesn't work. And then the other problem is that it means you only end up regulating half of the agreement. So if you decide that, like the greater than case, you decide that's a DBA, then the multiple of costs is unregulated. It's left at large. Whereas we say both elements should properly be regulated in the ways that the legislator has put forward.
If the multiple stood alone, nothing else at all, without a cap, it wouldn't be regulated.
If it was multiple
It
alone,
would only be regulated by the CAT's supervisory jurisdiction.
yes, if you're talking about a funders agreement, yes, my lord.
Yeah, if we're just talking about the funders agreement.
That's right, absolutely right, I accept that. I also wanted to deal very briefly with Lord Justice Burst's example of an agreement from yesterday, of an agreement that provides for normal hourly rates, but where the unrecovered portion will only be taken from damages. And I think I fumbled that a bit, to be perfectly honest, when your Lordship very fairly put it to me yesterday. Just to confirm again, that is both a CFA and a DBA, and so it's subject to both sets of regulations. The answer is that you can use that type of agreement. It's just that you need to comply with the percentage caps that are in the DBA regulations. So you need to take the unrecovered costs out of 50% of the damages, not out of 100% of the damages. So you
So I
should
really apologise to interrupt. Section 58(1) does not apply to anything other than those providing advocacy and litigation services.
Yes, that's right. I'm talking about the Lord Justice Burst's question to me yesterday
Doesn't
was
apply to
about a
funders.
solicitor making an agreement of that type. And that's why a solicitor making an agreement of that type would be making an agreement that was both a CFA and DBA. All I'm saying is that you need to take the unrecovered costs out of half of the damages rather than leaving your client with literally nothing. That's what the effect of the DBA regulations is. It's not anti-consumer, it's pro-consumer, because it gives that additional protection. So there is no problem. There are no gaping wounds of any kind. There are no wounds of any kind in relation to any of the CFA or DBA regulation that took place up to the end of 2013 on my reading of the Act. Whereas my learned friends are inviting you to make a finding which will be binding on all courts, short of the Supreme Court, in all cases, which will put people in a situation where we don't know how to deal with these hybrid agreements, or it just takes them wholly outside of one form of regulation or another. And my submission is that that would be the wrong approach. Finally, on this point, though, the one gaping wound, I don't accept it's a gaping wound, but the one issue that I can't solve fully is opt-out litigation in the CAT. Because that is the one situation where the fact that your agreement qualifies as a DBA means that it can't be done at all in this context. I accept that. I don't accept that that means that it's impossible to have opt-out litigation at all, or anything that reaches the heights of absurdity. For example, you could do opt-out litigation on a 100% CFA. You could use own resources for a consumer association. You could have funded opt-out litigation that was funded on the basis that the return will be whatever the CAT regards as fair and orders at the end of the proceedings. That's not actually that different from what we're talking about here, because at the moment, as your lordships all know, and as your lordships all said in the Gutmann case recently, other than in extreme cases, the CAT just doesn't exercise any scrutiny over the return ex ante. It saves all of that to the end of the proceedings ex post, leaving the fairness to be determined at that stage. Just for reference, that's Authorities Bundle, tab 28, page 1173. I anticipate that your lordships will remember the point. That's one solution. Another solution is that you could use an SPV for the class representative. That's already the case for two of the proceedings that we've got here. So then if the SPV doesn't have any other assets, there's not going to be any question of them having to pay out of the director's own money. So that's why I don't accept that we're in the realms of absurdity, even under the Competition Act. But the bigger point is this, which is that the change in the Competition Act 1998 in 2015 just can't be used to interpret the sections 58AA of the CLSA. And that is for the reasons that Lord Justice Burst gave in argument before, but not just for those reasons, because there is just no material at all before you to suggest that section 47C8, that in making that section, Parliament thought it was allowing in multiple spaced LFAs only, and only excluding percentage-based LFAs. That would need to be the statutory intention that you identify there, and there's just no material at all to support that. Of course, ultimately, if Parliament doesn't like the options that I've just outlined that would work for opt-out litigation, then Parliament's not liking the effects of what it has done in the legislation, and it can legislate to change that. It could do that in lots of different ways, and that is a reason why this court should be slow to try and fix the problem for itself.
Presumably, if all of these agreements were amended again, to delete completely the cap. So there's no cap at all. And forget issue 2 for the moment, just
Yes.
multiples, nothing else. Then they'd be perfectly valid on your case.
My lord, yes. And then there would have been no need to tear up the DBA
So
regulations.
they could, tomorrow, they could all amend their agreements in a way which would provide the class representative and the class with appreciably less protection than they've got at the moment.
I
These
look around
agreements
and I
would be
see
awful.
nodding. So, my lord, yes, that
Well,
is
it's
the
perfectly
position.
obvious in real terms, that must be the case, mustn't it?
My lord, it is the case that they could have done that all along and they could do it now.
Okay, good.
Right. I should deal very briefly with the additional points on issue 1 that Mr. Soul, KC, made. Those points were almost exclusively, I think, not open to the respondents to make, because they're not in support of findings that were made in the judgment, and they're not the subject of a respondent's notice. So I'll just run through them very, very briefly. One of the arguments, they're also wrong, so I'll explain why they're wrong. One of the arguments was that if you have an agreement which provides for a cap by reference to something that isn't the damages itself, isn't the proceeds, it's the undistributed damages, or it's the undistributed damages plus costs. So it's an agreement that is capped by reference to damages minus something plus something. There they say that is not a DBA because the cap is by reference to the wrong thing. And what I'd like your lordships to do with that argument, just to make it easier, is to think about an agreement, say a lawyer's retainer, which provided for payment of 70% of that category of thing. So 70% of undistributed damages, for example. Is it really being said that that would not be a DBA just because the thing that you're getting 70% of is not the total damages, it's something that is quite close to the total damages? In my submission, that would be an absurdity. That would be an absurd reading of the statute. It would render it completely nugatory. So in any other case, all you would need to do is you'd say, I'm going to have 70% of the damages plus £1. So 70% of the number which you get when you add £1 to the damages, or 70% of the number that you get when you subtract £1 from the damages. In either of those cases, they would say, Mr. Saul would say, aha, it's 70% of the wrong thing. And that's just not right. And what it actually does go to show is that they're wrong to substitute for the words determined by reference to, calculated as a percentage of. That substitution, which is at the core of my learned friend's case, is wrong because it gives rise to exactly this kind of problem. My approach is the right one, which is look at the whole formula. If you see damages in there somewhere, even if the damages are then multiplied by something or had something added to them or had something subtracted from them, if they're in there, then you do have a mechanism that is determined by reference to the damages. So that's what I say about that point. There was another point that was made, which was about the CICC opt-in case, I think, which was where, actually no, I think it might have been the opt-out, where you had the total fee, which was then through the priorities agreement being shared out between the lawyers and the funder and the insurers. And so he said, well, if the cap only applies to the total fee, and then that's shared out, then again it's not a DBA because it's not the case that the funder is having his return capped at the total proceeds. It's only this larger thing which is then being shared out that has been capped in that way. But again, that's vulnerable to the same criticism, that it's just totally open to abuse. You could have a DBA which says what we're going to do is we're going to take 70% of the damages as the total fee, and then we're going to share it out between the solicitors and the individual barristers according to a complicated waterfall formula of exactly the kind you see in the priorities agreement. And then what? It's not a DBA? It's not caught by section 47C8? It's utter nonsense. As soon as you've got the total, as soon as you've got the damages in there in the formula, determining the answer, you're caught. There was also a point made that the CICC opt-in agreement is not a DBA because it's an agreement between the solicitors rather than the class representative. I'm sorry, that argument is not only not subject to a respondent's notice, it was conceded. It's conceded below, and I'll give you the reference. It's the tribunal's judgment at paragraph 6, the core bundle A891. I don't suggest we spend time pulling it up. But that point was conceded. In relation to ATE, the Chancellor was right to say that I didn't make any specific submissions on it. The reason I didn't was because of my general submission that in all of these agreements, what you have is a cap, either express or implied. That's equally true for the ATE policies. The people who needed a respondent's notice to make an additional argument that even if I'm right about the cap point, still they're somehow not caught because they're not claims management services. Well, that's something that my learned friends needed a respondent's notice for, and I don't have time to deal with it now in reply. So, but all I would say about it, if you are going to deal with it, is that the wording, the definition of claims management services is incredibly wide in PACAR. It's anything that comprises financial, the provision of financial assistance.
PACAR, the Supreme Court did not decide ATE insurers were
No.
within claims management services.
Absolutely, my lord. Your lordship is right.
That really would have been a very
Well-
controversial decision, even more controversial than in some respects the decision they did make was, because insurance is governed by a completely different set of regulatory regime.
My lord, my
Which is why I
submission.
raised the point about ATE insurance, because it seems to me, okay, you chucked it into the grounds of appeal, but you haven't really dealt with it.
Well,
And
my
if
lord,
the point was going to be addressed properly, it would need a good deal more by way of submission than we've had.
well, my lord, I'm afraid that's not the way we see the argument going. Perhaps I can just give you some references. So the judgment below, core bundle 384, if you go away and look at 31 to 32, what you'll see is that the arguments that Mr. Saul wanted to make to you today were made below. They weren't accepted by the tribunal. The tribunal just didn't decide them one way or the other. Instead, the tribunal decided the case on the basis that we were wrong about the cap. We then appealed and explained that we were right about the cap. There was nothing for us to appeal in relation to the other points. If a respondent wants to make additional points, additional reasons why the overall conclusion reached by the tribunal is correct, that are not found in the judgment, the respondent files a respondent's notice. That's how it's done, and it's not been done. So it's just not before you. The good news is that no one is. You don't need to decide. In fact, I'm not inviting you to find positively that that having heard argument, ATE insurance is a claims management service. You don't need to decide that because that issue is not before you. It's been assumed in our favour. So that's issue one.
Has it been assumed in your favour?
Well,
They haven't decided it, have they?
the tribunal.
Where's it in
The tribunal below didn't decide it. That's right.
which judgment we're talking about?
So it's the CICC judgment, and if you go to
Paragraph.
it's paragraph 31 to 32.
It's paragraph 35.
Oh, sorry, 35. Sorry, 33 to 35.
35.
Yes.
Yeah, so the CAT hasn't decided the point.
That's right. And that means that if my learned friends wanted to rely on those points in this appeal, they needed a respondent's notice. That's what Part 52 says. And they don't have one. So that's the reason why the point isn't live.
Well, hang on a moment. I'm sorry to be awkward about this, but if the CAT has not decided the point and has said, as it says there, this issue could be dealt with at a later stage, it means dealt by the CAT. So the CAT has not decided. It's not part of the CAT's decision. It's not, given that one of the problems with appeals from the CAT is they never seem to make an order. But if we were dealing with this as an appeal, a normal appeal from Court of First Instance, it either would or would not be in the order, and if it weren't in the order, it would be the subject of an appeal to this court. So how can you say we should deal with the point in a way which is favourable to you, when it doesn't actually form part of the decision of the court, of the tribunal on which we're considering under appeal?
I hear that, my lord. I'm probably taking the point as about as far as I can.
Yes, I think you're taking a bad point with respect, but there we are. Okay.
That's issue one. Issue two, from the exchange that I saw earlier today, I can see that the court has understood, even if it doesn't agree with my point on construction of the legislation, that the agreement does provide for a payment determined by reference to damages, albeit in a contingency, and that's all.
We're just going to decide who's right and who's wrong about that. It's
Exactly.
a short point.
That's right. But there are a couple of additional points that were made that I do just want to respond to. One was that my learned friend prayed in aid the validity principle, which is the principle about the construction of contracts. That they say that you should strive for an interpretation that renders their contract valid. But this issue in front of your lordships is not a question of contractual construction. It's a question of statutory construction. And there certainly isn't any principle that you must interpret the statute in a way that renders their contract valid. That's not the principle. We all agree what the LFA means.
Well, it's all the other way around. Do we construe the contract so that it's consistent with the statute?
My point is, my lord, that there's no dispute about what the contract means. We all agree what those words actually mean and what they do. The question is whether I'm right that
It's the contract which is vague.
that's right. If it were, then
If it were.
Of course.
Yeah.
But here the contract isn't.
Right.
The contract is clear.
Yeah.
Okay.
In relation to policy, my Lord Justice Green, I asked earlier whether it was the case that the government was specifically concerned about speculative competition claims or was only concerned about non-competition claims. Again, just to give your Lordship the reference, it's the Supplementary Authorities Bundle, page 133, paragraphs 562 to 63. It's talking, they're the paragraphs I showed you yesterday. That's where they're talking specifically about competition claims. And they said one of the reasons that they adopted Section 47C8 was to avoid encouraging speculative claims. So that is squarely what they were trying to do. On the issue as to whether that policy concern is engaged here, perhaps if I can just explain further why that is the case. The concern is, what we mean by speculative claims, is the concern is that there's an expectation that you will earn more, or that you may earn more, if the claim is worth more. And what that does is it inevitably creates incentives to pursue cases that are not meritorious, or may not be meritorious, but have a small chance of earning spectacular sums of money. So if you consider, for example, a case where there's a 10% chance or a 5% chance that you'll earn £5 billion, and a 90 or 95% chance that you'll earn nothing. In that kind of situation, if you have a DBA with, say, a 30%, which is around the kind of number that we've seen in the cases, a 30% share of the returns, then you're talking about a sum of money that would be measured in billions of pounds. It takes you to a totally different order of magnitude than what you'd get without a DBA. And so that makes the prospect of earning those spectacular returns, that prospect inevitably makes those cases with those speculative characteristics, relatively more attractive than they otherwise would be.
Analysis of investment risk takes out of account the CAT supervisory power.
Well,
CAT might just simply not allow that.
it might not, and that is one of the contingencies. But of course, that was always true, and so you always could have said that. That's an argument for not having Section 47C8 at all.
No.
Because there's always a supervisory jurisdiction over all of the payments that are taken out of the money. So that's what Parliament was concerned by. Obviously, even before PACAR and even without Section 47C8, those jackpot incentives are muted by the prospects of success. And it's true that in the difference with these agreements, which are contingent on a change in the law, is that there is a further muting by the percentage chance that you assess of the likelihood of a change in the law. But what you're still left with is a situation where you've got some positive exposure to the jackpot. There's a chance, a small chance, that you will earn billions of pounds. And that is what inevitably, in my submission, gives rise to the concern that Parliament had. In relation to severance, I can be extremely brief. I don't want to say anything more about Zuberi. I don't think I can improve on what my learned friend said about that. For severance itself, just to clarify, we accept that this contract is blue pencilable. I can put it that way. That's an ugly phrase. And so that means it's not in the category that your Lordship, Lord Justice Green, was concerned with, where you had to rewrite the contract. That's not our point about this case. But beyond that, even once you've got over that first hurdle, you still need to get over the other hurdles towards severance. And that includes, in particular, the policy point. So that's in addition to the blue pencil, and in addition also to the question of whether you are fundamentally altering the nature of the contract. So even if you find, in light of the severance clause, that this is the kind of contract that the parties would have wanted to make, still you've got to get over the public policy hurdle. As to that, my learned friend points to Chitty and says that the public policy hurdle only applies where we're talking about criminal or other really bad conduct. My submission on that is that that's wrong, and that you can see that from the Volterra case.
Well, I was going to say the Court of Appeal decision in Volterra
which is
suggests that
binding on us.
The concept is broader than that.
Exactly. In any event, we'd say that these agreements are much more than just unenforceable for the reasons that my Lord Justice Burst gave. As for the argument about Volterra and how far that takes us, obviously we accept this is not the same situation. Obviously we accept that CFAs are different from DBAs in the respects referred to in that cases, but still you're left with the policy point, which bites, which is the same policy point I relied on in relation to into issue 2. So those are our submissions.
Thank you very much, Mr. Ritchie. Thank you. Right, well, we finished just about 5.
Just about.
Thank you all very much indeed for your extremely helpful and interesting submissions. We're conscious that these cases are, particularly cases like this, a team effort. Large numbers of solicitors from a large number of firms are involved on really on both sides, I think, you might be saying. And as I said yesterday, we're very grateful to the teams on both sides for having honed down the argument to presentation by one counsel team on each side. But we are conscious that this has been a team effort all around. We're very grateful. We're obviously going to reserve our judgment. No promises as to when you'll get it, whether you'll get it this side of the long vacation or not. We'll try, but we may not be able to. When you get the judgment, please pay attention to the terms of the embargo at the top of the judgment. And we'll invite any typographical errors, and that means typographical errors and the like, not inviting the court to reconsider its decision because you don't like it. And in due course, if you can agree the terms of an order, and if you can't agree the terms of an order, short written submissions on the matters you can't agree about. But otherwise, as I say, thank you all very much indeed.
Thank you, my lord, and thank you for sitting late. All 3 of you, thank you very much indeed.
Court rise if able.